tomorrow we cannot.
Lordship,
Tomorrow we are listing less numbers of matters, as many as we can, because we have some really meeting and all. So tomorrow may not be. Maybe
Monday,
on
Lordship.
Monday.
Monday, Lordship. Oblige your Lordship.
May I please also, I have to beg to mention item number 22 today list.
22.
And the matter may be 12.
CD we have received CD.
Not received, Lordship.
Are you on interim?
No.
Interim is
No. Can you madam 12th August?
12th of August. Remind.
May I please, Your Lordship? I beg to mention item number 36, Lordship. The legal counsel is out of station, Lordship, due to some medical emergency. Kindly adjourn the matter for 3 weeks.
Who MS and Hassan is the contacting counsel.
And Hassan,
She is out of state.
out of station.
36 and 37 both. But 37 was the Mr. Chetty, their RG.
Only 36, Lordship.
No, this is with criminal appeal.
Is seeking for adjournment, Your Lordship.
You are seeking adjournment for 37 also.
Yes, Your Lordship.
Yes, both the matters are listed together. In fact, maybe connected. I don't know.
No, 37 is for IA criminal appeal.
I is there in 37. One I is there.
Yes.
But 36 is connected with
Both,
37.
both are not connected, I guess, Your Lordship.
Not connected.
Same petition, it's a connected matter. I don't know, but whatever. Both 36 or 37. So in 37, why are paying adjournment?
As my senior is out of station, Your Lordship.
Your senior is also. Same order.
Yes, Lordship.
It's after review. Both the matters will be listed after review.
Nice.
May I please? Lordship, I beg to mention listing of bail application tomorrow. So let it maybe on Monday. Lordship.
Monday lots are there, most very Tuesday. Let it be on Tuesday. On 6th. Tuesday.
May I please, Lordship? I beg to mention item number 8, Lordship. Matter may come up after 2 weeks, Lordship. My senior ASIK is not well today, Lordship.
ASIK is not well.
Yes, Lordship.
ASIK. After 2 weeks.
2 weeks.
May I please, Your Lordship? I beg to mention item number 30, Lordship. My senior is out of station, Lordship. And the matter may be adjourned for
Who is your senior?
R. Ali,
R. Ali.
Lordship.
R. Ali was, yesterday R. Ali was here.
Yes, Lordship. Yesterday, second half, he went. Then,
Therefore, continue matters. The truth is after
much obliged.
May I please, Your Lordship? Your Lordship, I beg to mention item number 24 for withdrawal, Your Lordship. The suit
20?
stand 2024, Your Lordship, for withdrawal. The petitioner has already been arrested, Your Lordship.
already been arrested. Your name is not here.
Asma Bibi, TL Oscar, Your Lordship. TL Oscar. Your Lordship.
Yes, my instruction. That petitioner has already been indicted. And it will come. Okay, it will be disposed of.
Much obliged.
May I please, Your Lordship? Your Lordship, I beg to mention one bill application for listing for tomorrow, Your Lordship.
Tomorrow, tomorrow not possible. We are listing less numbers of matters tomorrow as many as possible.
Okay.
Which have already been fixed matters of we are listing. Tomorrow we have some actually meeting. So let it be either be Monday or Tuesday. And
Monday may be good.
Monday though there are lots in fact.
But Your Lordship, that the matter is of special nature. But is a senior citizen and bank official, higher authorities. So
Okay, let it be Monday.
May please, Your Lordship. With respect to item number 11 and 12, which are parted before Your Lordship.
Yes, yes.
Your Lordship, on the last occasion, gave us the liberty to mention if the matter could be given precedence or upgraded.
Yes, 11 and 12. Huh?
11 and 12.
My lord, can it be taken up at 2 o'clock?
At 2.
At 2.
Part of whose part we have heard?
The petitioner
Petitioner.
almost concluded his arguments. He was relying upon a few
At 2?
judgments.
Okay, at 2, sir, at 2. Or you want, Mr. Doctor, you want the timing, it should be at 2 because he is paying for
No, probably his senior wouldn't be arriving by the time it reaches.
at 2.
May I please also? Also, I beg to mention item number 15. CD was called for. I think CD is not available.
Yes, 50.
CD not received, Lordship, and the petitioner is on interim, Lordship.
I am on interim. Lordship. That may be extended.
Yes, will be acted, remanded. Yes, when can
27th, Lordship.
27th of August.
Lordship.
Okay.
Yes, item
May I
number 1.
please? Lordship, decision application under section 483 of BNSS Act, Your Lordship,
Yes.
and FIR page number 9, Your Lordship. 11 page number 13, Lordship. The allegation is that, Lordship, the daughter of the informant has taken into the vehicle, Lordship, along with the thief person, Lordship, and kidnapped, Lordship. And thereafter, she came to know that through the villagers that her daughter eloped with someone else, Lordship. And thereafter, Lordship, she also came to know that, Lordship, she was kept outside from the house of the accused, Lordship, and she was beaten by the wife of the accused as well as their family member. And that is the allegation, Lordship. And thereafter, Lordship, the police personnel has submitted the final report, Lordship, as per Annexure B, page number 14, Lordship, as under section 173 of CRPC, Lordship, wherein stated that, Lordship, not finding any evidence, Lordship, and witnesses, Lordship, and the girl, Lordship, eloped with the accused, Lordship, as because love and affairs between them, Lordship. That is the statement furnished by the investigation officer after proper investigation, Lordship, and same has been submitted before the court session court, Lordship. Accordingly, Lordship, accused was produced before the court, and same has been Annexure C, page number 20, Lordship. That accused was appears before the court, and subsequently he was remanded to the judicial custody and thereafter released, Lordship. And again, Lordship, only because of non-appearance, Lordship, in the various dated, Your Lordship, that is Annexure D1, page number 22, Lordship, the proclamation of attachment as well as the non-bailable warrant has been issued against the accused petitioner, Lordship, as a result of which he was arrested and produced before the learned district and session judge at Dhemaji. Same has been reflected as Annexure E23, page number 23, Lordship. Can you be produced? This order, Lordship, stated that the accused Midul Soikia has been produced before this court from District Jail Dhemaji. Remand him till 5/8/2024, as the accused has expressed his inability to engage any lawyer. Ms. Ila Borgohai, Deputy LADCS Dhemaji, is hereby engaged to defend the case of the accused, informed Ms. Ila Bargoha accordingly issue summon to the PWS Rizumoni Saikia, Anita Das and Babul Bora prosecution to take step. So since the accused petitioner is languishing in jail, Your Lordship, so the present application for release the accused on bail, Lordship. Prior to this, Lordship, earlier he was appeared before the trial court, Lordship, and initial stage he was participated in the trial proceeding, Lordship, and subsequently only non-bailable warrant as the proclamation attachment has been issued against him, as a result of which he was arrested, Lordship. And presently he is in
Not annex
language
the
in
other
jail.
order sheets.
Exactly.
You have to annex the order sheets.
Your Lordship.
Annex the order sheets. You have not annexed the order.
From 2018,
Yes, then last
Nothing.
27/3/2004
yes,
order,
nothing.
then only it came up. Our- wherein from the result of the record is that it's not at the order. Accordingly, done it wrong, but the map or planet track, passed by planet track 5. Accordingly, when it will be able to fight.
Within 7 days.
That is next week it can take. It's Thursday by Friday, 12 days.
Yes. Hello.
My lord, husband and wife, my lord, compromised. I am appearing both for the husband and wife, my lord. My lord will find the FIR at page number 9. I have also annexed a compromise deed, my lord. Page number 9 is the FIR.
The case was registered under which section?
498A is one of the sections and 384.
As per you, they have compromised.
Yes, my lord will kindly see page number 1919. There were cross cases. Both of them have agreed to withdraw. There are two, my lord may see. So in view of the judgment of the Honorable Supreme Court, my lord, in Gyanchand, followed by others, my lord, I can give a recent judgment, my lord, where matrimonial disputes, if they are amicable settled, then encouragement should be made for quashing of the same, my lord. My lord may rely on this judgment, my lord, because I am appearing for both the parties, my lord. Notice is also redundant in this case, my lord.
Affidavit is by the affidavit the next year is sworn by only Rahul Das.
Yeah, yes.
Therefore, we can get anything that he is also one party of time.
My lord, the
Yeah,
Wakalatnama is signed by both the parties.
Wakalatnama.
Wakalatnama, my lord, is. Husband and wife both. Affidavit can only be filed by one on behalf of the other. And the mutual settlement deed also I have annexed at page number 19.
Yes, sir.
I am deeply obliged.
Swam with us that of the present petition has been filed jointly by the informant. She was the informant. Yes. She was the informant.
My lord.
Informant victim. That's the accused of as and Uttarakhand filed by the victims as well and victims that informant it as petition number 1. It is subject that some standing there was some bit, but presently they have set all their bit and they're together as husband and wife. In the in person, they're in person, they've already entered into mutual agreement, mutual bit of agreement.
They have decided to divorce, my lord. They will part away.
Oh, that divorce.
Yes, they have decided. Page number 19, my lord will see the recital. And whereas due to some incompatibility, page 19, the recital. And whereas due to some incompatibility in their relationship, both the parties have mutually decided to dissolve their marital relationship and agreed to divorce under mutual consent of both the parties under the below mentioned terms and conditions.
They're not certain, but they mutually they with some terms and it said mutual bit of agreement was executed by both the parties on 11/3/2020, and in further state mutual agreement, settlement agreement, both the parties are also decided to withdraw cases filed by both the parties in each other. Apart from that, they have also for both some terms. Accordingly, what is the stage of the case at present?
My lord, that I am not aware of. But charge sheet is definitely not filed, my lord.
Not filed.
But the charge sheet is not filed, my lord. It is at the investigation. So the FIR, once the FIR goes, my lord, rest everything falls.
No, whatever. What is the stage? You must
My lord, charge sheet has not been filed, my lord, or else I would have come to know, my lord. It is at the no, not yet.
Not filed. And good, but as both as the matter has got mutually by another mutually by the jointly for praying for watching of the FIR of case 1733 dated 31 08 2020 under section 498 but died of the effect for the case of Jati versus State Mecha report by 2012 and straight on para conflict held as under
In fact, my lord, I have just now taken telephonic instruction. Even the divorce has also been done. Only the decree, they are waiting for the decree. Just now I had taken telephonic instruction. That may not be there, my lord.
General Rakpan and other versus Lobita no purpose serve it or if there are as that and as that it cannot be accepted from that it that info divided as we it party neighborhood and arrived at the and they explained it.
I'm deeply obliged. Ma'am.
May I please, my lord? My lord, the petitioner before lordship is a destitute lady, my lord. What happened in 2015, she got married with the respondent. And thereafter, my lord, they got two sons. After 2018, the my lord, husband, the respondent, my lord, he had some illicit relationship with lady. In fact, now it is come to know that she got married, he got married that another lady. In 2000, my lord, from 2018, in fact, from very first day onwards, the mother and my lord, the sister-in-law of the petitioner, the my lord, petitioner, they tortured her mentally because they belong to a lower caste. So that issue was going on from 2018. He started torturing heavily because he got another lady whom he got married later. Now, my lord, in 2024, what happened in January 24, she was detected some disease and she was treated in Bihar. Thereafter, she was sent back to her parental house, saying that you are suffering from cancer, you need some rest. But saying that they taken both the minor son along with them and sent them to somewhere in Nagaland and kept there in a hostel. The husband, along with the lady whom he got married. In fact, the lady taken both the son to Nagaland and kept them there in a hostel. Now, after when I went back to my parental house on their request, my lord, I come to know that yes, my lord, there is no such disease like cancer as they're saying. They're trying to separate me somehow from their house. So I came back on 19/5/2024. 19/5/2000. When I entered my house, matrimonial house, the husband was not there. Mother-in-law slapped me and with a dowel says my mother and father from the house, says they were my mother and father and me also. Then, my lord, I went to police. Police could not protect me. Police said it is a case of court. You go to the court. We cannot protect you because we have no other alternative. Then I approached the protection officer. Protection officer said you go to court. And the all reports are there in the protection officer. I filed a FIR there in the Patasil police station regarding all these things. Then what happened?
Went to the residence of Victor Das, a resident of Dadara village, under the jurisdiction of Dadara police outpost for a preliminary investigation. My lord, it's very important
to establish a physical relation with petition number 2. And that is another case, page 17. This is a FIR by petitioners. This petitioner number 2, Dipti Das. The place of occurrence is her residence, and they arrived. The victim arrived there for doing so all these things, and it happened. Now they said that they fled away from there when husband, petition number 1, noticed that thing, and now some neighbors are also ready. It is night time, so he may got the assault and unconscious after the treatment. After that, who has made this? And if this bail is not granted, then the message will go. Then when some do some immoral activities, some got injured by neighbors or somebody. So without knowing this code, who has done, even victim also has not given statement. At this stage, if bail is rejected, there will be without.
My lord, in this case, my lord, I have received 2 case diaries, my lord. The present case diary is, my lord, Abhayapuri PS case number 11024. Here, my lord, FIR is at page 11. Here, my lord, in this case, my lord, the present petitioners are husband and wife, my lord. Here in this petition, both the petitioners are husband and wife. And my lord, here the my lord, informant is one, my lord, Monindra Chandra Sil, my lord. He is the father of the, my lord, victim, my lord. My lord, as per his allegation, both the petitioners, my lord, out of a, my lord, pre-planned conspiracy, they invited the, my lord, victim, the son of the, my lord, informant to their residence, and thereafter, my lord, my lord, gagged her and my lord, physically assaulted her, and that is the case, my lord. And now, my lord, I have received the medical report. Yes, medical report is, my lord, previous injury. Earlier, my lord, the statement of the victim was called for. My lord, statement, because, my lord, statement is not available because, my lord, there is one another case. In that case, my lord, the victim is also an accused. And, my lord, from the both the case diary, my lord, your lordship, I will point out, my lord, your lordship may kindly peruse 164 statement of the here petitioner number 2, my lord, Dipti Das, and in other cases some of the witnesses are also available, my lord. And from reading the both the, my lord, case diary, it reflects that there is some illicit relationship between the here petitioner number 2 and, my lord, in the victim of that, my lord, case between some, my lord, Seal, my lord, Sumanto Seal, my lord, between Sumanto Seal, and because of that, my lord, entire incident occurred. And the petitioner number 1 is the husband of and on that day, my lord, probably, my lord, he came to know somehow, my lord, from the statement of witnesses about their illicit relationship, and thereafter, my lord, while there is, my lord, some illegal activities, my lord, going on between them, at that point of time, husband, my lord, reached home, and thereafter,
Who of the other FIR? Dipti Das.
yes, sir, your lordship may kindly
17,
page
17 annexure.
page 21 of the petition, my lord. The entire incident is, my lord, because of illicit relationship between petitioner number 2 and Sumanto Silva. And thereafter, my lord, husband invited the.
At night, neighbors are also there, my lord. Beyond reasonable doubts, no can be restored. But thing is that at place of occurrence, the victim was received for not for a noble acts, my lord. Some illicit act and got injured. So there is no statement of the victim also who has put the assault
So we
on.
have received the case diary of one of our
My lord, the present case is Abhayapuri 11024, and the second
Cross
case is,
case.
my lord, Abhayapuri 11124, filed by the petitioner number 2 here.
he got discharged from the
Hello?
the victim already discharged from the hospital.
Yes.
Yes, discharge, man, long time.
Your lordship may kindly peruse the statement of witnesses in the present case, and here, my lord, 164 statement of the petitioner number 2 of this petition. Entire picture will come out. This is 164 of petitioner number 2.
petitioner will cooperate with this police any condition. And number one is
and right of on the for about right and one of the but but of the not and but here enough one enough here support that it support is that the output from over it one and over one so support and okay so that very at up and that for one and that's all it up like the thing so I support the from that that or that that or it number that that okay you're granted with years great but they all there some condition appear before the IO within 70 and cooperate with
Right.
otherwise you're paid
Yeah. Deeply blessed.
Hey, please, my lord. My lord, I'm appearing on behalf of Mr. D. Deka. My lord, due to some difficulties, he could not appear today. So, can the matter be fixed after a week?
otherwise you have received the case
Yes,
diary.
sir. Case they received. No.
It not support the it. Are you on interim? Are you on interim? Interim
Yes,
petition was there?
interim was granted.
Was there protocol?
Then my lord,
No, was there interim?
in my
Yes, yes, interim was there.
yes, sir.
Interim because
Then on my lord,
when it can be
19th of August, 19.
you have to detail the case that can it be?
Because one of the medical report also my lord, regarding not yet received.
So you want to return it back or call it?
I will call one of the medical report injury report of one my lord Abu Said.
Otherwise,
Yes.
CD would be
Yes.
time. Fixing it on time.
May I plead your lordship? This is 430 revocation, your lordship. And allegations under section 326 and 334 of IPC, your lordship. Your lordship, I kindly, there is an extra one, your lordship. That is the translated copy of the FIR, your lordship. May I read, your lordship? Sir, with due respect, I beg to state that today on 28/4/2024, about 9 a.m., Shri Rajdeep Das, son of Bhagya Das, a resident of Pani Chokwa Gaon, PS Polibur, the district of Jorhat, Assam, along with an unknown boy called my grandson, Vikas Borua, near our gate, and Shri Rajdeep Das injured my grandson with a sharp weapon on his chest and escaped in a bike along with the boy. As a result, my grandson was severely injured, and our family members immediately took him to the hospital. Well, let's say there's a kind. I want to make a submission on that regard, your lordship. If I had in the shoes of the informant, your lordship, I would have done the same thing by just registering the FIR, your lordship. The only thing is that allegations are that I have injured the victim, your lordship, but the actual fact of it is something else, your lordship. The whole scenario of the case is that, your lordship, I saw the victim lying on the ground of his own home, your lordship, and I saw the victim lying on a blood of bull, your lordship. It is the main reason I just went near him just to pick up him, your lordship. And meanwhile, the victims or the parents came out and saw me, and as a result, they shouted that I have injured the victim. But no one saw me regarding any weapons that can conceal the case, your lordship. It is the main submission of me, your lordship. As per the FIR, your lordship, I have been just made a scapegoat on this case, your lordship, and nothing else. The allegations, I'm not telling the allegations are whatever. They are totally baseless, your lordship. Only on the thing is that the parents of the victim saw me, your lordship.
Your name is not there in the FIR.
Your lordship?
Your name is not there in the FIR.
No, name is totally there, your lordship. But the thing is
Name
that.
is there. Where?
No, my lord,
Oh,
name
sorry.
is not.
Rajdeep, your lordship.
Yes, the name is there, my lord, Rajdeep Das.
Rajit Das.
Rajdeep Das, your lordship. The only thing is that the parents saw me, your lordship, and they shouted. But they didn't show me with the weapon, your lordship, whatever I have done or whatever. I just saw when I was going through the gate, your lordship. I just saw him lying on the pool. Somebody might have done the thing. And if your lordship may grant interim bail, your lordship, if 3 days bail, I will definitely wholeheartedly cooperate with the investigation of police, your lordship. And this FIR was lodged on 28/4/2024, your lordship. It has been around 3 months, since 3 months, your lordship.
Case diary received, my lord. Injury report also received, my lord. 164 statement of eyewitness and injured is also available in the case diary. And they, my lord, in fact, in 164 statement of the injured person and the eyewitnesses also stated the name of the present petitioner. And injury is, my lord, grievous. So eyewitness also stated the name of the present petitioner, and one other person is also there, my lord. But specifically, his name is mentioned by eyewitness. An injured person also stated that name of the present petitioner, Rajdeep Das.
Your lordship, the only thing is that I'm a small businessman. I'm running a small business shop, your lordship. I'm absconding since, your lordship, since the FIR, lordship. If I'm granted into a 3 days bail, your lordship, I'll definitely cooperate with the investigation case, your lordship. Otherwise, the case will go on and I will be absconding without any punishment, your lordship. I wholeheartedly request you only pay before, your lordship.
Vital portion of 164 statement is not legible, but my lord, from the note of the IO, that 164 statement and eyewitnesses stated the name of the petitioner. That is, my lord, specifically mentioned.
It is known in that locality as a very
Yes. Yes. And why vehicle portion of the 164 statement is not legible, my lord, it is difficult. But my lord, in the note of the IO and everywhere that regarding 164 statement, name this person, that is my note.
His brother was also there.
Yes, ma'am. Proktinda. But he is not the petitioner here, ma'am.
But it's not
And some of the witnesses stated that since earlier there is some enmity between them. Ma'am.
regarding the earlier cases, there is no note.
Yes.
Regarding his earlier involvement, but here statement is that he is a very little kind of
Yes.
person,
Yes.
and that location is doing not. So, Mr.
Mr. N. Milli, your lordship.
and Mr. and
Lordship, if you may allow me a
Yes.
connotation regarding this,
Yes.
your lordship. As a legal, as a jurist person, I also want this case to be moved forward, your lordship. It is the reason, if you grant me pre-arrest bail, your lordship, you will definitely cooperate with the investigation and the case may proceed further, your lordship.
forward.
Your lordship, if you grant me, your lordship, pre-arrest bail, then your lordship, I will definitely cooperate with the investigation of police, your lordship, because I am appending since 28/4/2024, lordship, and I run a small business, your lordship, and I am the sole earner, bread earner of the family, your lordship.
You want to basically cooperate the IO.
Cooperate if you can me pre-arrest bail.
What to do that? What can it be given here for the interim only?
Yes.
That's not. That he is the person one pick up that stop him time to look that, but when he tried to up family member of the all hit him that the thing that he solved it. How I but that report up that not the name of the president after that as well difference and but the trap of their court at the month and also corporate provide. Okay, you all continue one interim protection.
Yes.
Appear before the IF and go.
Definitely.
Yes, what up?
Yes, sir.
When
On my lord, 12th of September. 12.
Deeply obliged.
Maybe so. My lord, this is an application under 438 for 3 years bail. My lord will find the FIR at page 10. Second paragraph is the relevant part. Madam, may I read it, my lord? As the information, my husband Meghraj Newar and village Gaonpura were sitting in the veranda of Meghraj Newar's home, and suddenly Amar Chauhan, that is the petitioner, came there and attacked my husband, Sri Bhanu Bhakta Rizal, with sharp weapon, Tarwal, to kill him. But fortunately, he saved the weapon with hand, and his hand, mouth, cheek, two cheeks, but the English is as it appears, my lord, were badly out by the weapon. So, my lord, that is a solvent substance. The other part is, my lord, may be quite relevant, as the information they were discussed about recent political matter by phone, and Amar Chauhan, that is a petitioner, loaded sharp weapon in his e-rickshaw and attacked to kill in the spot. This is purely a political conspiracy, is what the FIR says, my lord. And, my lord, based on which the case was registered under section 447, 326 and 307 IPC, which would make the injury report as well, injury report and the ingredients very relevant, my lord. And, my lord, following the incident, the petitioners, the wife of the accused, she also lodged a FIR, alleging that the victim, the so-called victim, had trespassed into the house and had, attempted to outrage her modesty. That, my lord, will find at page 12 the FIR, the cross FIR. But, my lord, I don't know if on the basis of this FIR, any case has been registered. To my instructions, my lord, there was a move to settle the matter amicably, and that is why the cross FIR was not registered. My lord will just read paragraph 2 of the cross FIR, my lord, page 12. My lord, the second paragraph becomes relevant, my lord. The cross FIR, it throws light on the circumstances that prevail, my lord. After some time, Bhanu Bhakta Rizal, that is the victim, my lord, and other persons came to my house with sword, started looking at me with dirty eyes, and the accused physically assaulted me and with malafide intention or outraged my modesty, and started quarreling with my husband on this matter. At that time, my cousin brother, Sri Meghraj Newar, come and took them to my Sikh cousin's house to solve the problem then, and threatened me and my husband to cause death or grievous hurt. There was a delay in filing this application to maintain good relations with neighbors and for settling the matter amicably. My lord, what emerges, my lord, whether the case has been registered or not, the cross FIR is relevant. There was an altercation between both the parties, involving both the parties, and, my lord, there was an attempt to sort out the matter. So now, my lord, whether the ingredients of the offense is present, or whether the injury report throws any light on the nature of injuries sustained, that my friend would probably appraise the court.
My lord, the injury report in the format is not available. Otherwise, my lord, that there are witness of the statement of the victim is available, my lord. He was first admitted in Turkadar Croc Memorial Hospital, subsequently shifted to GMC for better treatment. Referred to Guwahati for better treatment, whether GMC is not reflected. Otherwise, from the statement of the eyewitness also, my lord, চোকা তৰোৱালৰ আক্ৰমণৰ ফলত ভানু ভক্তৰ এটা আঙুলি কটা যোৱাৰ লগতে দাঁত আৰু গালত আঘাত পায়। And as per the statement of the victim, my lord, the Kumare উপস্থিত মই নিজকে বচাব চেষ্টা কৰোঁ যদি মোৰ আঙুলি লগতে দাঁত আৰু গালত থকা তৰোৱালখনেৰে আক্ৰমণ কৰে তেনেকুৱা গাঁওবুঢ়া আৰু আনসকল উপস্থিত আহি আমাৰ হাতৰ পৰা তৰোৱালখন কাঢ়ি লয় এণ্ড এজ পাৰ এজ চিজাৰ লিষ্ট মেলত ওৱান iron made toroor 75 length. It's seized from the Gambura, but he fled away.
Obviously, but the question is that whether he have received the medical report.
Medical
Because
report.
he sustained injury on his teeth also.
Yes.
Whether there is any loss of teeth and etc. That has
And
if there is
medical report not available.
discoloration and etc. That obviously
But as per the statement of the medical report not available. Statement of the eyewitness also, এটা আঙুলি কটা যায় লগত দাঁত আৰু গালত আঘাত পায় and as per the statement of the victim also injury in hand mouth and teeth but medical report not available.
Not for the medical report.
Yes,
Because
yes,
we have
it's necessary.
to include this, suppose if any disfiguration is
But-
there, suppose it's here that injury in the one of the finger was already cut.
And
So medical.
yes, medical report is necessary.
And my lord, whether the cross case, whether any case has been registered on the basis of the cross fire that I had lodged.
Yes, but your instruction it is not yet registered.
It has not been registered, but it may have been, my lord. There's almost a month gone.
Instruction is that is
Ma'am?
there any
Only for the reason that, my lord, it is between family members, my lord, and there was an attempt to sort out the matter amicably. Whether it could have been done or not. My lord, the fact is an attempt was made.
That kind of report is not available in the case that
My lord.
if suppose there is any suspect
It
department
can be
or
obtained by the
uh,
also.
that have been there in the case that let's stop here.
Hello.
Regarding your submission that there is a amicable
Uh-huh.
process is also there because
Hello.
of family members and all, but that is now most probably is not available in the case that.
Hello.
So if your case is registered or not, that cannot be adjusted.
Hello.
That can be instructions can be taken.
I'll take instruction.
But however, medical test not if they allow about time to obtain the medical test except the mistakes are one process was also lost by wife of but as chapter is wet that process is registered or not. For us, recording cake as well it was tried by the wife of it. CD call to details
Within the city and call for the injury report.
according when it can be
Malathon 21st.
21st.
Obliged, my lord.
May I please your lordship? Due to some personal difficulties, the engaged counsel Miss S. Nazneen is unable to come today. Kindly your
His
lordship,
diary is received at
Well,
kindly your lordship, fix the date on 9th of August.
9th.
9th of August.
Oh, that's not the time. Yes, wait.
May I please, your lordship? My lord, the FIR is page 9, my lord. The relevant portion is 10. Here, my lord, the assistant engineer of PWT Gwalpara lodged the FIR against the present petitioner. It stated in the FIR that, my lord, the present petitioner by force the order of the officer and tried to load 12 pitch of iron joist in the truck, and in the meantime, the informant's team came there and found him while he was loading the iron joist. Then it was seized and handed over to the police station. Hence the case, my lord. The fact of the case is that, my lord, the present petitioner is a labor by profession. I have stated in paragraph 7, my lord, clearly. And on the day of alleged incident, one Orupjyoti Doimari, he came to the place of incident morning, and the iron joist means, my lord, a bridge was repaired and some disposal, my lord, item was lying near the bridge, my lord. The item is disposal item, my lord. Already bridge repaired, and since long days the item is lying there. That Orupjyoti Doimari came, and petitioner's house also near the incident, my lord, and found the petitioner there and saying that I am the official authority and I will send a vehicle, you will load it and I will give you the, my lord, labor charge. Accordingly, my lord, 12,000 paid to him, and evening he sent the truck, my lord. That person, on belief of that person, started to load the iron joist, 15 numbers, in the truck. And some person of the locality informed the office that disposal article is taking somebody else. Then the team come and found him and caught red-handed. And the person he is played away. When they charged him, he said that on Orupjyoti and showing the order also in the WhatsApp. The order, what happened, my lord?
Who played away?
The present petitioner.
So he is saying that he
No, freed away means that time when they tried to caught him, what you are doing, he replied the story. These are the story. One person morning came, he said that I am the official authority and I will send a vehicle, you will load it. Accordingly, I am trying and loading now. But it was not still now taken away. And on WhatsApp of the present petitioner, the order was sent that person in WhatsApp, my lord. Original order was not with him. He showed that informant, this is the WhatsApp order. He informed me, if anybody come, you show the order. Accordingly, my lord, he showed the order. Even then, they, my lord, did not agree and tried to caught him. It is admitted fact, he immediately played away. Now the petitioner before your lordship, this is the story, my lord. He is a, my lord, labor person, my lord, he has no idea. So the article also, my lord, not stolen away. It is already seized. So my humble submission, my lord, since he has stated that on Orupjyoti Doimari and WhatsApp also has come from which mobile, my lord, the police can also, my lord, investigate. If the Honorable Court allow him to go on, my lord, he will cooperate the investigating agency and he will show the WhatsApp also where from this order has come.
Learned friend stated that he is in labor. In the case diary. Letter I am the impugn letter order. It's from sign is from Chief Engineer PWD Sanmari to PWD Gwalpara Executive Engineer. Disposal of condemned 25 numbers of iron angle cutting to Shakil Rahman. He is the petitioner. So in the order itself, his name is there. If he is a labor, now there are some directions that cutting should be within 15 days, 40 feet length, and maybe cut in 2 pieces in 20 feet. All this. And when he was uploading in the trying to upload in the truck with the JCB with 15 wheeler truck and JCB, he tried to leave this iron. At that point of time, some neighbor people came and who are you? Why is that I am a contractor and with help of this order I am doing this. Then they informed the PWD authority of the Gwalpara and they went, and now it is a certificate given by the Gwalpara PWD office with reference to the letter of that number 55-24. This is to certify that the above mentioned letter, namely in the letter is Manjit Mahanta, Chief Engineer, PWD Sanmari, and Pranab Sharma, Executive Engineer, PWD Golpara, are not belongs to our department. This is a fake letter. That order is fake.
WhatsApp letter, ma'am.
WhatsApp,
Because
and
the present
he-
petitioner
no,
gave that
let me
WhatsApp. It is also printed from WhatsApp.
And that letter, he is saying that he is a laborer. But in that letter, his name was there.
Yes, name has taken morning. That
And,
person,
now it
and
is
he
a
sent the
fake letter.
WhatsApp.
It's a fake letter. On the basis of the fake letter, they are trying to, if no one came, he might have uploaded this in a track. And that authority, PWD, witness are there, PWD authority, these are the fake letter, and the basis of the fake letter is doing this. And some persons of the neighboring, their statement also there, they kept, but he paid away.
In fact, offense is not committed yet.
Offense not
because
committed,
on Arupjyoti Doimari, that present person is a police person, my lord. My lord, he is now victim. The present petitioner is the victim. Why compel submission, my lord? The article is not, my lord, destroyed. It is already under the custody, my lord. Nothing, my lord, destroyed, my lord, or no benefit has been got here. And that name has taken morning, that Arupjyoti Doimari, and he sent the present petitioner in his WhatsApp. When the
Police did not find the here is there no name of or is not.
not yet, my lord.
No, I am submitting, my lord. We have the story I am saying, my lord. In fact, the present petitioner is the victim, my lord, now. Otherwise, my lord, kindly examine whether it is the, my lord, the original order or not. It is the WhatsApp order, my lord. Now, from the WhatsApp, police print out, my lord. Because when informant came, my lord, the present petitioner gave this WhatsApp,
This
my
is
lord.
the impure letter, and
So, my lord,
one certificate is also
nothing
there.
is lost, my lord. Everything is okay, my lord. So he will cooperate the investigative agency, my lord. Because the money also 12,000, my lord, gave that person. As a, my lord, labor search, GCB search, all everything, my lord. So when offense is not yet, my lord, completed, kindly may consider, my lord. He will investigate he will, my lord, cooperate the investigative agency, my lord. Very poor person, my lord, the labor, my lord, he does not know the system and which way it have to left. Actually, my lord, the vehicle had to go in his custody, that Arupjyoti Doimari. He will get the benefit.
Certificate I have taken, my lord, one certificate.
So definitely it is false, my lord, because therefore he original did not give to the petitioner. Only in WhatsApp, the Arupjyoti Doimari sent to the present petitioner. If anybody come, you show this WhatsApp.
Is the paper paper of the opposite one German to what's the paper and ask to edit for one carry all item of both items I got it which were everything is but and that or the that it is 12,000 presented that this passport is but from but like it but derivative from this I it but it order made in paper of a present and on a word with the that the later was report uh, I got and there are one that was what stating that it is on the input that and it out as it was from to Gwalpara address PWD Gwalpara Gwalpara and Gwalpara. It's part the paperwork of why order but then submitted how order the fit and put out from what and from record that it like remind but it the of the order and put and the kind of but that kind of like it at the Gwalpara on what it is okay. Your petition stands
What is at page number 15.
page number
15, ma'am. 23, I think. 23.
23 my lord city Kesari not
Not, if the Lordship will kindly see the nature of the allegations, my lord. Basically, the allegation is that, my lord, the petitioner, along with his family member, they had assaulted the informant with a crowbar. That is the allegation, my lord. If the Lordship will kindly see the vernacular, my lord, at page number 15, it says that, my lord, এক নম্বৰ আসামীজনে লোহাৰ খন্তাৰে মোৰ বাওঁ হাতত মাৰপিট কৰি হাত ভাঙি দিয়ে। And the FIR, my lord, was registered under 120B, 341, 325, 307, 506. So, my lord, 325, my lord, is available. Regarding 307, the petitioner or the any accused, my lord, must have the intention that he, by that act, must, in normal circumstances, must cause death. My lord. In this case, my lord, admittedly, my lord, the blow was in the hand of the informant or the victim, my lord. So, apparently, my lord, my humble submission is 307 may not be attractive in this case. So, if the Lordship wants to grant interim protection, my lord, he will appear, my lord, he will cooperate with the investigation. Because prima facie, my lord, it's not a case of 307 or 325.
well earlier case diary was called only on 23/7/24 my lord. One chance may be allowed, otherwise earlier my lord on 27 city was closed. Any short date my lord, if my lord in the case diary nothing is there my lord, then definitely he will get petitioner will get objected with bail my lord.
I could not annex some orders, my lord, where the other co-accused were granted previous bail because they were not certified. But there, my lord, the court considered the injury report. The injury report was of grievous hurt with blunt weapon. So it's 325, not 326. And 307 private facie, my lord, is not attracted because the blow was on the hand.
Not only hand, my lord, head also specifically mentioned, like on her head. which can iron rate, iron rod.
Iron rate on
Oh, on her head, my lord.
on
Head,
head of the
yes.
No, but
লোহাৰ ৰডেৰে মোৰ পত্নীৰ মূৰত আঘাত কৰে।
but the injury was only with regard to the accused number 1, and not the informant.
who is wife. Wife.
Yes,
Here,
his wife.
Is the wife only.
Wife. If your lordship will kindly peruse the order, my lord, of the lower court.
We reported wife also.
Yes, yes. Simple injury.
Well, on 10-9, my lord. 10-9.
Highly obliged.
Yeah, 25 also, my lord, case diary not received.
May I please your lordship? My lord, kindly see the FIR, my lord.
whether my lord 376 will come or not, my lord.
Also respect provided because that on first it was called
Yes, my lord. Kindly turn to page 11, my lord. Whether my lord 376 will attack or not, my lord. Because my lord, consenting party, my lord.
Only 164 statement.
My lord, affair is my lord. She is the victim, is the informant here, my lord. And that, my lord, what is the ingredient is the affair, my lord. Consenting party, my lord, and there was an agreement for my lord marriage, my lord. So my lord, 417 may come, but that is bailable offense, my lord. But kindly see the affair, my lord. My lord, here, my lord, informant is the victim, my lord. So, my lord, 164 will, my lord, remain same, my lord, because the affair was lost by herself, my lord. So, my lord.
Yes. 198, my lord.
My lord, it will be so long, my lord. Kindly short date.
And my lord,
Because, my lord, time is not granted.
14.8, no? 14.8.
Oblast. Oblast.
May it please your lordship. The 438 application, my lord. Petitioner is a my lord carpenter, my lord. My lord, the complainant is a sister-in-law of the accused petitioner, my lord. And wife of the accused is the younger sister of the complainant husband, my lord. Please may kindly see the FIR, my lord. If one of good permit me vernacular, my lord, everything is clear, page 17, my lord. This FIR was lost after 28 days when incident alleged, my lord. Page 17, my lord. May I read, my lord? FIR file on 35/2024 সন্মান সহকাৰে জনাও যে যোৱা ইংৰাজী 4/5/2024 তাৰিখৰ আগৰ পৰা মোক পদকীয়াই হোৱাটছআপ যোগে বেয়া শব্দ ব্যৱহাৰ কৰি অশ্লীল ভাষাৰে মেছেজ কৰে লগতে মই মোৰ পৰিয়ালক অৱগত কৰোঁতে পৰিয়ালে মোক বুজাই যে যিহেতু মোৰ স্বামী আৰু সৰু ভণ্টি গিৰিয়েক বুলি মই বুজাবুজিৰ মাজত চলি এবাৰ ভণ্টিক কথাষাৰ জনালো তাই গিৰিয়েকক কি ক'লে মই নাজানো সেইদিনাই অৰ্থাৎ 4/5/2024 শনিবাৰে আনুমানিক 8 মান বজাত ৰাতিপুৱা মোৰ ঘৰত আহি দুইজনে মাৰপিট কৰে চুলিত ধৰি চুচুৱাই বগৰাই কাপোৰ কানিত ফালি পেলাই মোক মোৰ শাহু মা কোনোমতে মোৰ প্ৰাণ ৰক্ষা কৰে তাৰ পিছত মোৰ শহুৰে মোক ভুল বুজি মোক মোৰ মা ঘৰৰ দেউতাৰ ঘৰলৈ পঠিয়াই দিয়ে তাৰে কেইদিনমানৰ পিছত মোৰ স্বামী গুৱাহাটীৰ পৰা আহি মোক ঘৰত লৈ যায় তাৰে এসপ্তাহ মানৰ পিছত মোক বাটত অকলশৰীয়াকৈ লগ পায় আৰু মোক জোৰ কৰি বলপূৰ্বক ধৰ্ষণ কৰিব বিচাৰে মই কোনোমতে নিজৰ প্ৰাণ ৰক্ষা কৰি আহি মোৰ স্বামীক কথাষাৰ কওঁ মোৰ স্বামীয়ে যেতিয়া ধমকি দিয়ে জেল যাব বিচাৰিছা নেকি বুলি কওঁতে আমাৰ ঘৰৰ পৰিয়ালৰ য'ত য'ত আলহী আছে সকলোকে মোৰ চৰিত্ৰহীন বুলি মোক অপমানিত কৰিছে আমাৰ ঘৰৰ আহি শাহু সৰু ওচৰত মোক কাটি পেলাম বুলি পানে মৰা ভাবুকি দিছে যিহেতু মোৰ এখন সুখৰ সংসাৰ আছে বুলি মই ইমান দিনে মনে মনে ধৈৰ্য ধৰি আছো কিন্তু এতিয়া ধৈৰ্য সীমা শেষ কৰি মোৰ স্বামীও মোৰ পৰিয়ালে সাহস দিয়াত মই আৰক্ষী চকীত হাজিৰ হ'বলৈ সাহস কৰিছো সেয়ে near perusal of this FIR there is a 3 incident first incident they give some message he give some messages obscene message and thereafter she says that the accused along with his wife is coming and some assaulted and কেইদিনমানৰ পিছত আকৌ again in the road say that তাৰে কেইদিনমানৰ পিছত মোৰ স্বামী গুৱাহাটীৰ পৰা আহি মোক ঘৰত লৈ যায় তাৰে এসপ্তাহৰ পিছত মোক বাটত অকলশৰীয়াকৈ লগ পাই মোক বলপূৰ্বক ধৰ্ষণ কৰিব বিচাৰে there is no date there is no place time আৰু কোনোমতে নিজৰ প্ৰাণ ৰক্ষা কৰি আহি মোৰ স্বামীক কথা ক'ব টোটেলি my lord is a my lord, is not a pure true case, my lord. And my lord, main behind this, my lord, if honorable could permit me, my lord, paragraph 5, everything is there, my lord, 5 and 6, if our lordship read it, my lord. What is the problem? Main issue. Main issue is, my lord, is my wife, my lord. She is always doubting me to his go, I think. Please may kindly see paragraph 5. That the accused petitioner respectfully beg to state that the complainant Srimati Aruna Bharali Sharma is the sister-in-law of the accused petitioner. The accused married with Srimati Jonali Sharma Bora, who is the younger sister of the complainant's husband, namely Prafulla Sharma. The petitioner, being a son-in-law of the complainant family, he always visits to his in-laws' house, and there is a good relation between above two families. Due to business purpose, the husband of the complainant mostly reside out of station, and parents-in-law of the complainant are old-aged person. Thereby, he always visit his in-laws' house and help them in their daily activities whenever they need. There used to be frequent telephonic conversation between complainant and accused petitioner. Moreover, sometimes when complainant is in need anything, she inform the accused petitioner through her WhatsApp or phone, and thus accused petitioner come to help her, and thus they had a good relation. And for this reason, the wife of the accused petitioner always doubt the accused petitioner with the complainant, and for this reason, there used to be frequent quarrel between the accused petitioner and his wife. The accused petitioner respectfully beg to state that almost 1 month before filing this aforesaid FIR, the complainant called and asked the accused petitioner to come to her house to discuss some important issue. Being a son-in-law, he went there, and complainant asked some money amount to rupees 10,000 from the accused petitioner, as she had some problem in her parental house, and promised to return back the money as soon as her husband come back from the workplace. The accused petitioner did not inform his wife that complainant asked him money. It is also mentioned that at that moment, accused petitioner did not have sufficient amount money with him, and thus he asked an amount 5,000 from his wife by giving her a false reason. Hereafter, the accused petitioner paid an amount 10,000 on 23/2024 to the complainant. Thereafter, on several occasions, the wife of the accused petitioner asked him about the money and where he have utilized it, but petitioner did not answer to it, which created more doubt in the mind of the accused petitioner wife, as his wife always doubt him with the complainant. On 4/5/2020, the first citizen, my lord, in recorded in the FIR, during in the morning hours, while son of the accused petitioner was playing games in the accused petitioner mobile phone, he saw the WhatsApp conversation between accused and petitioner and complainant, and immediately informed it to the accused petitioner wife. The accused petitioner will be to say that his wife, after knowing about the WhatsApp message, scrolled. My lord,
Yes.
my lord, this is my lord, totally my lord, the family, my lord, and my lord is due to doubting my wife is creating the scene, my lord. And thereafter, my wife also complained in VDP, and thereafter, my lord, this published the news, my lord. So she filed this FIR, my lord, and this FIR, there is no my lord material, my lord, against the 373, 354, nothing, my lord. And
My lord, otherwise, in her 164 statement, she implicated, but from the FIR, my lord, he is the, my lord, husband of her sister-in-law, my lord. So, for which, my lord, probably FIR, although incident occurred on 4/5/24, FIR laws on thereafter on 35. Maybe some kind of relationship, but it is, I cannot say at this point of time without having such, my lord, any such material in the case diary, my lord, from other witnesses also. But otherwise, my lord,
my lord,
some kind of, my lord, relation may be there, but may not be there. But that is, well, from the CD, my lord, now from the 164 statement she implicated. And regarding delay of lodging the FIR, because in this type of incident, for which my lord own sister, husband of the sister-in-law, otherwise, my lord, considering all these aspects, my lord, I will leave it to your lordship, my lord. Let him record his statement, my lord.
And I may be allowed to appear.
Study license may not be required. Otherwise, those things are not impossible also, man. And without having any such material regarding any illicit relationship, my lord, at this point of time, it is also difficult to say, my lord, record that there is any such relationship without having such material in the case therein. Yes.
Environment. Environment.
Okay. And
Going in Gopur TS man. Gopur police. Matsu. Matsu.
May it please your lordship. My lord, here FIR is that I have inflicted thou blow in his sim. That is the allegation, my lord. And here the crux of the matter is this, my lord. We that the informant, that this particular victim, Ellie's victim informant, and I myself are the employees under the railways. So, my lord, there were some differences for long regarding the fact that night shift and day shift. I'm putting it before in just 2 minutes. Because they don't want to do the night shift, they want to do the day shift, both of, including my
petitioner also. Then, my lord, that victim, Ellie's victim, he had some relation with one senior person. So that his name is also there. They conspired and they have put him in the night shift. So there are some differences. At that point of time, my lord, there was a World Cup match going on, and everybody was watching that particular match in that institute. One institute is in the railway premises. Then what happened? This the other guy, the victim, was in some manner he was regularly provoking him, and these things were going on. It is a fact, my lord. There are some scuffle between both of them. That guy fell down in a later part, and fell down. He got injured, and to be honest, they were having liquor and all these things. Bottles were there. He fell down, got injured. This is the fact. And here he has just that Your Honor will see, your Lordship will see that this particular FIR, it is well drafted one. That everything is, we can see it by it is by a technical person. We can understand that. Thereafter, my lord, this incident, actual fact, we have put it at page number 16 annexure 3. What has happened actually? In that scuffle, Your Honor, your Lordship, he was wearing a chain, this accused person. Here is a gold chain wearing, and it weighs around 32.33 grams and is of 1,90,000. This was snatched by that person in the scuffle, Ellie's victim. So my wife went to the police station and filed this FIR. This is a cross FIR. And my lord, that particular person who was in who was their superior authority, he has used all his influences. Your Lordship would be to inform your Lordship. After 15 days of the FIR, without giving any opportunity to be heard, he was dismissed from his job also. So high-handedness is there, and this particular victim, Ellie's victim, he had enough earlier this antecedents, criminal antecedents in the railways also. I think that will come up in the case there. So my humble prayer before your Lordship is this: since he is a railway servant, a government servant, whatever will assail that process. At this stage, if he goes into custody, his chances of reviving his job would be there, and he is married. He has a daughter also. So at this stage, I think that injury will say what type of injury, but to my instruction, that that particular person fell down and there was bottle. So there was a scuffle, admittedly, from both the sides. He was also coming with his friends, attacking me, and snatched my chain. I'm ready to cooperate, my lord, at any condition, because for this case I cannot go because they have registered under 307.
My lord, 2 injury reports available in the case diary, and my lord, one of the letter written by this senior, my lord, letter means that is my lord an FIR actually, my lord, that was probably not registered. Your Lordship may kindly see by last portion, my lord, his senior Arnab Sinha, allegation is against. Yes, my lord. That, my lord, while these, my lord, informants trying to save their senior, then the accused person assaulted, my lord. No. Earlier, my lord, there was an attempt also to assault the senior also, my lord, that is.
That senior person was not in the scene, my lord.
Your Lordship may kindly go back my the same my petitioner, my lord. Both are the of the petitioner. One from my lord railway hospital, and one is of the my lord GMCH. My.
AMCS में AMCS होगा
AMCS में
तुम BNF BNF
But now
yes yes
How is it? Is it?
name is my lord Biplab Das.
Biplab Das.
Your,
Biplab Das petition.
no, victim is,
My lord.
who is the victim?
Victim is my lord Joyanto Zit Roseli, my lord.
Joyanto Roseli.
Joyanto Zit Roseli.
Joyanto Roseli.
My lord, another aspect to the matter, my lord. Some colleagues are intervening in between them because they were colleagues for long. So probably there would be a chance of amicable settlement also otherwise. So at this stage, if I am taken to custody, two things are because I will lose my job. I cannot, that would be, because actually assaulters were there, this particular victim, they assaulted him. And my chain is also taken. My lord, it's a fact. So whether it is coming on the CD, I do not know. Because I am not able to appear there because of the apprehension that I will be arrested. So, and the technical part, I'm not going on to that, whether, because if it is hit by a dove, these are, my lord, like, your lordship can understand that it would have been something more serious. Injuries are there. That there were like scuffle, that fell down also. So at this stage, if your lordship allow me on any condition, subject to let my statement be recorded, at least I may be heard.
No, otherwise, my lord, your lordship has already materials is there against the person. The primary my lord, earlier also, my lord, he is not, his character also, conduct is also, my lord, not good since earlier. So let him, my lord. Otherwise, if your lordship were to give us a, considering that he submitted that matter is going, but there is, I think, from the after going through the case, there is no any probability of any settlement. Let him appear and record the statement, considering his, my lord, service only, because otherwise he. Otherwise, also he is under suspension.
No, I have to file appropriate application.
Otherwise, there
for
are
that
sufficient materials against the accused.
My lord, only on that ground.
Yes.
We are the
Yes.
Deeply open.
On my lord, 10-9 minutes.
Deeply open.
have filed your
Yes, yes,
file.
yes, sir. Sir.
So it, their protection as not as what, but
Yes.
I
529.
and
Section
your
529.
Your petition was to take. Okay, I have already dictated your
Yes.
so only for one. So it allows your eye accordingly.
Yes.
To read as or three.
482 may be read as 529. Yes.
Your eyes.
Yes. All right.
Heard any other?
Yes, yes.
Any other?
Factual part, man, I had completed.
Yes.
Only one.
Petitions mean one. Oh, there are two petitions.
There are two petitions. One more thing I would like to point out, my lord, if your lordship kindly takes up item number 12, my lord.
We have said earlier, don't repeat back.
No, I will not repeat. Page 56, my lord, of the second case. This is the FIR lodged by the complainant, my lord. If your lordship reads the FIR, not even a whisper against me, my lord. Me and the petitioner in item number 12. Here the accused is only one, my lord, at page 57. It is one Nirupa Jodhani, my lord, who is the accused number. Four, I think. Four, accused number 4. Here there is no allegation of 316, my lord. But in the complaint, my lord, there is an improvement in the case. 316 is brought in, 192 is brought in. Of course, there is a sentence, my lord, in that regarding 192 that they had tried to manipulate evidence. But on the last occasion, I have submitted that the reading of the complaint does not disclose an offense under 192 so far as I am concerned. 316 could not have been, my lord, because 304A and 3116 cannot go together. To bring in 316, my lord, there has to be culpable homicide. I'll rely on Allahabad High Court judgment, my lord. It is reported in, my lord, 1965. AIR 1966, Allahabad, page 590. How 316 has been interpreted, my lord? Para 11 and 12. The next question which arises, my lord, lordship has got it. The next question which arises is, what is the offense committed by so-and-so alone in pushing Srimati so-and-so and trying to kick where she was in an advanced and visible stage of pregnancy? The trial court has convicted the appellant Jabbar under section 316. This section reads as follows. I'm not reading the section, my lord. Let us read the section, my lord. Whoever does any act under such circumstances that if he thereby cause death, he could be guilty of culpable homicide, and does by such act cause the death of a quick unborn child, shall be punished with imprisonment of either the description for a term which may extend to 10 years, and shall also be liable to fine. It is clear that section 316 IPC can only apply if the action resulting in a death was capable of amounting to culpable homicide. The section does not specifically state that the action must be directed against the mother and not the quick unborn child. From the illustration to the section, which is intended to clarify the meaning of the act, it appears that the act must be of such a nature that the offense committed against the mother herself would be culpable homicide, if the mother had died as a result of it. If the act is intended only to cause miscarriage without the consent of the mother, it would fall under 312 and 313 or under 314 IPC. If the act is intended to cause the death of the child before its birth or to cause it to be after its birth, it is an offense punishable under 315. Hence, an offense under 316 must be deemed to refer to acts directed against the mother, and these acts have to be such a character that the offender would have been guilty of culpable homicide if she had died. The resulting injury to the child carried in the womb of the mother may be quite unintended, and yet an offense under 316 would be made of. So for 316 to come in, my lord, there has to be an assault on the mother, knowing that that assault could lead to her death, and that death would be culpable homicide. Here the allegation is that I did not try and deliver the child. So for that, my lord, 316 cannot come. Now coming to the issue of 304A, my lord. Lordship will kindly take up the 2005-6 SCC, my lord, page 1. The judgment of Jacob Matthew, my lord. Copy আছে না? আগতে দিয়া আছে। Para 12, my lord, at page 16. Negligence as a tort and as a crime. The term negligence is used for the purpose of fastening the defendant with liability under the civil law and at times under the criminal law. It is contended on behalf of the respondent that in both the jurisdictions, negligence is negligence. And jurisprudentially, no distinction can be drawn between negligence under civil law and negligence under criminal law. The submission so made cannot be countenanced in as much as it is based upon a total departure from the established terrain of thought running ever since the beginning of the emergence of the concept of negligence up to the modern times. Generally speaking, it is the amount of damages incurred which is determinative of the extent of liability in tort. But in criminal law, it is not the amount of damages, but the amount and degree of negligence that is determinative of liability. To fasten liability in criminal law, the degree of negligence has to be higher than that of negligence enough to fasten liability for damages in civil law. The essential ingredient of mens rea cannot be excluded from consideration when the charge in a criminal court consists of criminal negligence. In so-and-so versus so-and-so, a bench of 5 and other law lords agreed with him. He reiterated his opinions in so-and-so and dealt with the concept of recklessness as constituting mens rea in criminal law. So, my lord, in order to bring in 304 against me, 304A, there has to be mens rea. Not to speak of establishing, my lord, even mens rea is not even pleaded, my lord. Now, what intent would I have of killing the lady or the child, my lord? Now, paragraphs 18, I'm not reading, my lord. I'm relying on paragraphs 18, 24, my lord. In para 24, the sentence beginning with in tort. Now, this is on tort, my lord. But here the Supreme Court has said that a mere accident or a wrong decision, that will also not amount to negligence. Now, in paragraph 27, it is said that res ipsa loquitur will also not apply in criminal cases. Then, my lord, in 34, paragraph 34, the general exceptions in section 8892, my lord, that has been referred to. Para 38. Here, an earlier judgment is referred to, my lord. Then 48 is the summary, my lord. Lordship will kindly come to page 48, page 33, my lord, paragraph 48, subparagraph 5. Lordship has got it. The jurisdictional concept of negligence differs in civil and criminal law. What may be negligence in civil law may not necessarily be negligence in criminal law. For negligence to amount to an offense, the element of mens rea must be shown to exist. For an act to amount to criminal negligence, the degree of negligence should be much higher, that is gross or of a very high degree. Negligence which is neither gross nor of a higher degree may provide a ground for action in civil law, but cannot form the basis of prosecution. Here, my lord, they are pursuing a case against us in the consumer forum. My lord. We are contesting it. No difficulty in that. But so far as criminal case is concerned, my lord, it's absolutely an abuse of the process of the court. Now, lordship will kindly come to page 52, paragraph 52 at 35. Statutory rules or executive instructions incorporating certain guidelines need to be framed and issued by the Government of India and or the state governments in consultation with the Medical Council of India. So long as it is not done, we propose to lay down certain guidelines for the future which should govern the prosecution of doctors for offences of which criminal rashness or criminal negligence is an ingredient. Next line, my lord. A private complaint may not be entertained unless the complainant has produced prima facie evidence before the court in the form of credible opinion given by another competent doctor to support the charge of rashness and negligence on the part of the accused doctor. Now, where is that, my lord? I have shown the evidence is of only two witnesses, of the complainant himself and the mother-in-law. No documents exhibited, no report. So therefore, the prerequisite for taking cognizance in the present case is not there. And it is not for the tribunal, not for the magistrate to call for a report, my lord. If we read it again, my lord, it is for the complainant himself or herself to produce the evidence. Next is on the FIR, my lord. The investigating officer should, before proceeding against accused of so and so, obtain an independent medical report. So, my lord, the order taking cognizance as well as the complainant is an absolute violation of this judgment of Jacob Matthew. Now, how this has been interpreted and relied upon by our High Court, my lord. 2013, my lord, 4 GLR, page 870. Here, my lord, lordships will get the facts at paragraph 3, my lord. I am not reading everything. Here, there was an operation done in the hospital itself. There was an overdose of anesthesia, admittedly. The patient could not be shifted. She died there, my lord. Even under those circumstances, this honorable court has held that no, criminally they are not liable. And how everything, my lord, Bhajanlal has been quoted. Facts, lordship will get at 4. Then in paragraph 7, my lord, the celebrated case of Bhajanlal has been referred to. Then from paragraph 15, the various judgments have been applied to the case. Para 20 may be referred. Para 20, my lord. Coupled with the above, the term negligence may be used for the purpose of imposing civil liability on a defendant and at times to impose criminal liability. In order to enable a court to hold that there was existence of criminal rashness or criminal negligence, there must be material to show that the rashness was of such a degree as to amount to taking a hazard, knowing that hazard was of such a degree that injury was most likely imminent. Similarly, the negligence, in order to have criminality, have to have a degree of negligence that the care which was required to be taken had not been taken at all. The element of criminality gets attracted when the accused had run the risk of doing an act with recklessness and indifference to the consequences, despite knowing that the hazard involved in his act was of such a degree that injury was most likely imminent. Now, if your lordship turns to, now Jacob Matthew has been referred to from paragraph 26, my lord. And how it has been interpreted, lordship turns to page para 29. paragraph 52 is just above that what I have just now read, my lord. Para 29. From what have been laid down at para 52 in Jacob Matthew, it becomes clear that in a complaint case, a complaint cannot be entertained, since after the decision in Jacob Matthew rendered by the Supreme Court on 5th August against a medical practitioner for an offense allegedly committed under section 3404 AIPC while performing surgery or administering anesthesia or in taking necessary post-office care, operative care, unless the complainant has produced prima facie material before the court in the form of credible opinion given by another competent doctor to support the accusation of rashness or negligence on the part of the accused doctor. So the burden lies on the complainant, my lord. The complainant cannot come and say that let me file the complaint and then I'll produce the records. No, my lord. He has to produce prima facie evidence that yes, there is some negligence. How to, what is that report? Jacob Matthew explains in paragraph 52. And lastly, my lord, in paragraph 34, the petition was allowed and the order taken cognizance was set aside to the extent of the petitioners. So therefore, my respectful submission is, my lord, that first, no allegation of 192 is even pleaded against me. Now, one more paragraph of Jacob Matthew I have left out, my lord, which is relevant, where the apex court has discussed that this tendency of prosecuting doctors, my lord, it is not congenial. Para 28 of that Jacob Matthew judgment, my lord, 2005-6 SCC. Para 28. Page 22. A medical practitioner faced with an emergency ordinarily tries his best to redeem the patient out of his suffering. He does not gain anything by acting with negligence or by omitting to do an act. Obviously, therefore, it will be for the complainant to clearly make out a case of negligence before a medical practitioner is charged with or proceeded with against criminally. A surgeon with shaky hands under fear of legal action cannot perform a successful operation, and a quivering physician cannot administer the end dose of medicine to his patient. 29. If the hands be trembling with fear, with the dangling fear of facing a criminal prosecution in the event of failure for whatever reason, whether attributable to himself or not, neither can a surgeon successfully wield his life-saving scalpel to perform an essential surgery, nor can a physician successfully administer a life-saving dose. Even 30 and 31 may also be considered, my lord. Because the doctor gains nothing, my lord. Here in the present case, the patient has come in the emergency while trying to save the mother. And if your lordship, that statement of course is not in the records, but my learned colleague, my lord, here obtained certified copies of the status report filed by the police in that FIR, my lord. If your lordship permits me, I'd like to place it, my lord. The FIR, certified copy of the FIR is there. But the police had started the investigation, my lord. Statements had been recorded. Statements of both my client as well as the petitioner in item number 12, my lord, they were recorded, my lord. If your lordship takes up the last page of that, this is part of the report. Second last page is it's a status report submitted by the SI. Roman 5, my lord. Statement of Dr. Pranab Methi, that is the petitioner in item number 11, and Himlina Gautam, petitioner in 12. of Apollo Hospital were also recorded, and they stated that on 15 July, one Mrs. So-and-so, aged so-and-so, was immediately shifted to ICU from emergency and received at 12:15 a.m. in cardiac arrest condition. So the cardiac arrest had already happened before that. Initial ECG on monitor shows so-and-so. These are all medical terms, my lord, which means that a patient is alive at that time. Carotid pulses were not palpable, and immediately CPR started. While CPR is going on, cardiac rhythm intermittently shows so-and-so. Shocks given thrice. So all attempts were made to save the patient. My lord, is it possible that the mother is dying? The doctor will say, no, let her die, and perform a surgery at that stage, my lord, to take out the baby, my lord. My first line of argument is, my lord, under Jacob Matthew, in any case you could not have taken cognizance. Para 52 bars taking of cognizance. I have gone a step further. My submission is on a reading of the complaint. 304A is not made out against the petitioners. Because the only allegation I have read out, my lord, last occasion, is para 13. Para 13 is the only allegation against me. And what is the evidence led, my lord? The critical care specialist of Apollo Hospital, so to speak, of Dr. So-and-so, allowed to die a healthy baby in the mother's home. This is clear and undeniable case of criminal negligence. Page 29. It starts at 28. Para 13. This is the only allegation against me. And I have again placed, my lord, I will not, because their own doctor at page 34 had said that the baby could not have been saved in Apollo. Had it been a case, it would have been saved in that, in IHR, na? Institute of Human Reproduction, IHR. That is at page 34, my lord, only last occasion I had pointed out. So my respectful submission is that the reading of the complaint, my lord, does not make out even a prima facie case against me, my lord. 192 is not alleged, 316 is not made out, and even 304 is not made out. That is my respectful submission.
I'll have the submissions of my lord. Right.
Yes.
Nothing
From
else.
12.
I'm for the petitioner in item number 12.
I appear in both the matters for the complainant. In both of them. May it please the Lord. Broadly speaking, what I've understood from the submissions given by my learned friend, he has made basically two broad challenges, one to the cognizance order and one to the complaint case itself, on the ground that it does not make out any prima facie case. The plain reading of the complaint does not make out any prima facie case. As far as the cognizance order is concerned,
my lord, another matter has been called in another court, my lord. May I take your leave, my lord? My colleague is here, my lord. If anything is there, my lord, they will call me. Oblige me.
as far as the cognizance order is concerned, on the previous occasions, I have made a submission that the cognizance order itself is not sustainable enough. To that extent, I had already considered and had made a proposal that the matter be remanded to the trial court so that the independent opinion from an expert medical board can be obtained, and thereafter the matter could be proceeded under 202 of the CRPC. However, they were not agreeable to that suggestion and they wanted to challenge the complaint case itself. My first submission on the illegality of the cognizance order is that the kind of errors in the cognizance order which will vitiate a proceeding and the kind of errors in the cognizance order which will not vitiate a proceeding, those have been laid down in section 460 and 461 of the CRP. But just because the cognizance order is bad in law, that will not make the proceeding vitiate. Your Lordship may kindly come to section 460 and 461 of the CRPC. 460, irregularities which do not vitiate proceeding. If any magistrate not empowered by law to do any of the following things, namely, the Lordship may strictly come to subsection E. To take cognizance of an offence under clause A or clause B of subsection 1 of section 90. This is basically taking of cognizance based upon a police report or on a private complaint. So if a magistrate of second class who is not empowered to take cognizance based upon a police report or a private complaint takes the cognizance, because of the lack of jurisdiction, the proceeding will not be vitiated. Our case stands on a stronger footing. The first class magistrate who has taken the cognizance, she was competent to take cognizance, but the guidelines laid down by the apex court in various cases relating to the medical negligence field or area, those were not followed. And that is an error committed by the court. The basic principle regarding any error committed by the court and the error vitiating the proceeding is that because of an error committed by the court, the party or litigant cannot suffer. The golden principle of actus curia neminem gravabit. This has been reiterated by the Supreme Court as recently as in 2023. I will place the judgment later on. I will not come to the judgment right now. The only kind of error in the cognizance order which will vitiate a proceeding is defined in 461. Lays down the irregularities which will vitiate the proceeding. 460 was the other way around. If any magistrate not being empowered by law in this behalf does any of the following things, suppose a second class magistrate takes cognizance, subsection K, takes cognizance of an offence under clause C of subsection 1 of section 90. 191C is basically taking cognizance on the magistrate's own knowledge. Magistrate's own knowledge or the information gotten by some other person other than an informant or a complainant. Because the second class magistrate does not have the basic jurisdiction to do these things. That is why the second class magistrate taking cognizance of an offence based on his own knowledge or from some information heard from some other person, that will completely vitiate the proceeding. Under these A to Q, all these irregularities, the kind of irregularity which has been done in this case does not find any mention. So therefore, the argument that the error in the cognizance order that will itself vitiate the proceeding, that is not sustained. So I'm still agreeable to the position if the matter is remanded to the trial court for taking the opinion of an expert body to come to the finding that there is a prima facie case of medical negligence. As far as the merits of the case is concerned, whether the plain reading of the complaint makes out a prima facie case, reliance was placed upon Jacob Matthews. Jacob Matthews' case was further considered in the subsequent judgments by the Honorable Apex. Because the thrust of the argument is that the complainant, he himself should get the opinion of a competent medical board. First of all, I do not have the access to the papers relating to the treatment of my wife. Those are with Apollo. Even if I have the copies of those documents, I cannot constitute an independent medical board. That is the duty of the Honorable Magistrates Court, which has been considered in the subsequent judgments of the Apex Court. Martin F. D'Souza's case, this has actually clearly laid down the legal position with respect to taking cognizance in respect to medical negligence. This has not been relied upon. And even if I get an opinion of a medical board or some independent medical practitioner, will that be really independent? It has to be constituted to be independent. The board has to be constituted by the court. In several cases, the board has been constituted from the Delhi Medical Council, from the Maharashtra Medical Council. Lordship may kindly come to page 23 of the judgment which I have placed just now. Martin F. D'Souza's case, AIR 2009, Supreme Court 2049. Jacob Matthews was 2005. Para 117. This is a clear law laid down by the Apex Court after having considered Jacob Matthews' case. Because Jacob Matthews' case says may not be entertained. It does not say it shall be dismissed. if it is not accompanied by a medical opinion. 117, this is the operative part which is binding. We therefore direct that whenever a complaint is received against a doctor or a hospital by the consumer fora, whether district, state or national, or by the criminal court, then before issuing notice to the doctor or hospital against whom the complaint was made, the consumer forum or the criminal court should first refer the matter to a competent doctor or committee of doctors. It is a duty attributed to the court, specialize in the field relating to which the medical negligence is attributed. And only after that, doctor or committee reports that there is a prima facie case of medical negligence, should notice be issued, then issued to the concerned doctor or hospital. This is necessary to avoid harassment to doctors who may not be ultimately found to be negligent. We further warn the police officials, so this is not important. So the binding precedent in cases of medical negligence by the doctor or a hospital is that it is the prima facie duty of the court. Because me being the complainant, me being the victim, firstly, I do not have access to the treatment papers based on which the doctors will opine, based on which the medical board or the independent doctor would opine. I do not have access to the papers of Apollo Hospital. And even if I am able to get a copy of those documents, I will not be able to constitute the board because the opinion has to be independent. And if it has to be independent, then it has to be constituted by the court as per the guidelines in Martin M. D'Souza's case. As far as the factual part asserted by my learned friend, Your Honor would kindly consider the submission made by my learned friend just now, that the complainant cannot expect the doctors to make a delivery of the baby at the cost of the life of the mother. If that is the case, if both the lives are at risk, then I should be given an option. In any such case, I should be given an option. That both the lives are at risk, whether you would like to save your baby. That option was never given. It would come out from their own statements. It would come out from their own statements given before the Assam Human Rights Commission. I was never given that option. And if that submission is sought to be correspondent with the pleaded case of the other doctor in item number 12, the obstetrician who had treated my wife, her pleaded case, although the pleadings will not determine a criminal case, it has to stand the test of cross-examination. Your Honor would kindly come to page 7 of criminal petition 1460. Item number 12. An assertion, a specific assertion has been made by Dr. Himlina Gautam, who was the obstetrician treating my wife. The petitioner, herein being the obstetrician on duty, examined the fetal heart rate. It is the heart rate of the baby, of the unborn baby, inside the mother's womb. And the same was not to be found. Now, this is in clear contradiction to the oral submission made by my learned friend in item number 11, because the factual situation that was thought to be projected was that only one of the two lives could be saved. If this was the case, that the baby itself was not in a position to be saved, then that particular assertion is missing from the other doctor's pleading. If this was the case, nothing like it for them. But if this is the factual position, that there was no fetal heart rate, that the unborn baby did not have any heart rate, and that there was no possibility of saving the baby, then that particular assertion should have been made by them in their statements given before the Assam Human Rights Commission, which has been annexed by them. Your Honor would kindly come to page 52 of criminal petition 1457. Your Honor would kindly just go through it. There is no whisper about the baby. There is no whisper about the unborn baby. If actually there were attempts made to save the baby, And those attempts should have been reflected in the statement. And the assertion by Dr. Himlina Gautam was that since there was a cardiac arrest, there was no possibility of saving the baby, because after 5 minutes, that is the medical literature probably they're relying upon. But whatever be the opinion, that has to stand the test of cross-examination. It has to come from a body of expert doctors. Now, if there was a cardiac arrest and there was no possibility of saving the baby after 5 minutes of the cardiac arrest, then the statement given by Nirupa Jodhani, who was the attending doctor of the patient at Goenka nursing home, her statement is relevant because she said there was ROS, page 53 of that particular statement given by the Apollo Hospital. Into acute pulmonary edema with decreasing oxygen saturation. After a brief period of recovery, the patient had cardiac arrest. Patient was immediately put on ventilator there. CPR done for 5-7 and ROSC, return of spontaneous circulation, was achieved. So the spontaneous rhythm was again achieved. So at what stage there was a situation that the baby could not be saved at all? That we are not clear. That can be clear only from a medical board's opinion. That is what I am praying, that the matter be remanded to the trial code under 202 so that these specific points can be cleared. And this is the safest course of action for the doctors. If the cognizance order is set aside and the matter is sent back to they will not be facing any trial. The learned trial court will take specific opinion on the specific issues which require determination. If what they are saying is true, the opining will be done by the independent medical board based on the treatment papers provided by them. Only they will be providing the treatment papers. If this is the situation that the baby could not be saved at all, that would be the opinion of the medical board. But it should come from a medical board. This is not a finding to be arrived at under 482. The assertions which have been made by them, these are matters of trial. Regarding one of the conversations with my own doctor, which I had at the time of treatment of my wife at Goenka Nursing Home, that has been reproduced by me in my private complaint. One of the, that particular doctor, Dr. Rita Bhuyan, she had made a statement over phone. I have honestly reproduced the entire contents of that telephonic conversation. That if the baby could have been saved, she could have been saved at IHR itself. Now that opinion is not an independent opinion by independent medical board. This particular conversation, it was reproduced by me in the complaint petition only to show that the doctors themselves admitted that many nursing homes and many hospitals in Guwahati are operating without ICU. That was the prime purpose of reproducing that particular telephonic conversation with Dr. Rita Bhuyan. Now, this particular assertion that if the baby could have been saved, she could have been saved at IHR itself, that is not a independent medical board's opinion. This could not be relied upon to absolve them of the allegations which I have left. Regarding the three offenses, 192 is definitely not pleaded by me. To that I agree. That 192 is basically against the doctors and the anesthetists of IHR or Goenka Nursing Home. Section 316 I would come. I have an interpretation of that particular section of penal section. If your honor would kindly come to section 3048. whoever causes the death of any person, the one prime point for determination would be whether the unborn baby in the mother's womb can be considered as a person or not. Because a person, to be considered as a person, has to be one with having certain rights under the law. The first right of an unborn baby inside the mother's womb is that of right to life. An unborn baby under the Indian law has the first right, which is the right to life. Because whenever a woman who is sentenced to death, if it is subsequently found out that the sentenced woman is pregnant, then the sentence is deferred till the delivery of the baby. Under section 416 of the CRPC, postponement of capital sentence on pregnant woman. If a woman sentenced to death is found to be pregnant, the High Court shall order the execution of the sentence to be postponed and may, if it thinks fit, commute the sentence to imprisonment. Now, since the unborn baby in the mother's womb has a right to life, this is the precise reason why the capital punishment is deferred and postponed. That is the unborn baby's first right under the Indian law, that is the right to life. Secondly, under the Transfer of Property Act, rights can be vested in an unborn baby under section 13. I will just read out your honor. Where on transfer of property and interest therein is created for the benefit of a person not in existence at the date of transfer, subject to the prior interest created by the same transfer, the interest created for the benefit of such person is the unborn person, shall not take effect unless it extends to the whole of the remaining interest of the transfer in the property. So therefore, the unborn baby exercises a right of being vested with property even when in the mother's womb. So the unborn baby has certain rights under the Indian law, for which precise reasons the unborn baby is a person. And if there is a negligent act leading to the death of an unborn baby, that would clearly come under the provision of section 304 AIPC. Section 99I of the Indian Succession Act, 1925. Section 99, subsection Roman small I. All words expressive of relationship apply to a child in the womb who is afterwards born alive. In many cases where the complainant had himself exhibited a particular opinion from a medical college, that was rejected subsequently by the criminal court on the basis of the fact that it was constituted by a different body, and when the criminal court takes cognizance of an offense relating to medical negligence, then that has to come from the government, statutory government body. I will place the judgment. This is 2012 SEC Online Delhi 3334. I've highlighted the portions on which I'm relying. I would just like to read these particular paragraphs because specific emphasis upon being laid upon the fact that I did not go to the criminal court with an independent medical court opinion. In Jacob Matthews' case, the Supreme Court has already observed that once the criminal process is initiated, this subjects the medical profession and the professionals to serious embarrassment and sometimes even harassment. The accused apprehending arrest may have to seek bail, which may or may not be granted to him, and therefore this becomes imperative that the greatest possible care is taken that no doctor is put to peril of being arrested or facing a criminal case without observing the procedure, which has been laid down by said judgment, which precisely the court was trying to do in the instant case. The apex court in the said case has also observed that a private complaint may not be entertained unless the complainant has produced prima facie evidence before the court in the form of credible opinion given by another competent doctor. It was also observed that the IO should, before proceeding against the doctor accused of rash or negligent act or omission, obtain an independent medical opinion. Even in this case, the duty is upon the IO if it is upon a police report. It is only in the investigating agency's powers to request the particular government body or statutory body to constitute a board, because these are not within my powers. Preferably from a doctor in a government service qualified in that field of medical practice, who should normally be expected to give an impartial and unbiased opinion. If this standard was to be observed by the court before registration of an FIR against the applicant intervener, it was necessary that a fresh opinion from the board duly constituted by the Delhi Medical Board. It has to be, the opinion has to come from a statutory body, has to be obtained, and once the petitioner has put the criminal justice machinery into motion and she has not produced any prima facie evidence with regard to the medical negligence, it was not open to her to have retracted her steps belatedly and then urged before the said trial magistrate or before this court that the order passed by the learned magistrate directing for constitution of a board of medical council to furnish medical opinion be recalled in case there is already an opinion furnished by the doctors of Maulana Azad Medical College. What happened in this particular case in the criminal trial, the complainants were trying to rely upon an opinion given by the doctors of Maulana Azad Medical College. Even that was rejected. Only the opinion given by the committee constituted by the Delhi Medical Council, that was relied upon by the criminal court. If that has to be done, that sort of transparency and that sort of authenticity has to be attributed to a medical opinion. These are not within my powers to request the government to, or this is the clear dictate of Martin F. D'Souza's case, where the court has said that it is the duty of the court to constitute the board. This is on account of two reasons. Firstly, that the opinion furnished by the board constituted by the doctor of Maulana Azad Medical College was constituted by a consumer forum and not by a criminal court. Moreover, the report furnished by the said board is already under challenge by the applicant's intervener in as much as their application has been allowed and the notice issued to the petitioner stands accepted. Now, if this has not been done, even after the clear dictate given by the Honorable Apex Court in Martin F. D'Souza's case, then that particular irregularity or illegality in the cognizance order will not vitiate my complaint. This is the time-honored principle of actus curia neminem gravabit. I will not read it out. I'm just placing it for your lordship. In this case, a particular compensation amount was directed to be disbursed to 2%, which was wrong. And then the court itself directed that the matter be again refunded and thereafter it should be disbursed to the correct person. Because of an error committed by the court, the party or the litigant shall not suffer. As far as the chief ingredient of section 304A is concerned, the emphasis is on a negligent act. Emphasis is on a negligent act. It is no way connected to mens rea. Because if 304 is to be interpreted or expected to include the element of mens rea also, then it would be no longer 304A. Because nobody is saying that the doctors had the intention of killing the child. It was a negligent act. Because they did not make any attempt to save the baby. I was not given that option. I was not given that because as a father, I'm entitled to that option. If such was the oral submission made to the effect that only one of the lives could have been saved, you cannot expect us to take out or deliver the baby at the cost of the life of the mother. If that is the factual situation, then I should have been informed about it. I should have been given the option. And that particular assertion is contradictory to the stand taken by the other doctor, Dr. Himlina Gautam in the other case. She is saying that there was no fetal heart. If that is the case, it should have found mention in the AHRC statement, Assam Human Rights Commission statement. And regarding the higher degree or gross degree of negligence, the complete absence of any attempt to save the baby, that is the higher degree of negligence in this case. Because the baby should find at least some mention. It should find some mention in some of their papers, in some of their statements. The baby is completely vanished. There is no mention or whisper in any of the treatment papers which I have with me now, but I cannot rely upon them since it is their case. Actually, I can go into that. Even the minimal papers which I have with me, those papers also do not mention about the baby. Even the statement given by them before the AHRC, which has been annexed by them, that also doesn't mention about the manner in which the baby could not be saved, or at least this particular mention that the mother was brought in such a situation that the baby could not have been saved. That is not their case. So I would just summarize my submission. If the challenge is made to the cognizance order, I'm already agreeable to my learned friend that the cognizance order is not sustainable in law because the cognizance order was taken without taking the opinion of a medical board, independent medical board. So that itself will not vitiate the proceeding in view of section 460 and 461 of the CRPC. Further, on the principle of actus curia neminem gravabit, the party or the litigant should not be made to suffer because of an error or an illegality in the cognizance order. Regarding the factual assertion in oral mode, it was part of their oral submission that the complainant cannot expect the doctors to deliver the baby even at the cost of the mother's life. That particular stand is contrary to the stand taken by Dr. Himlena Gautam in the other. So the factual situation is completely contrary as with vis-a-vis the doctors. Regarding the FIR, which was lodged by me on the very day of my wife's death. Definitely at that point of time, I was in a monstrous kind of trauma. In that particular situation, it also slipped my mind. It is only after looking at the papers, their statements given before the AHRC, that this particular fact came to my knowledge. But what about the baby? Why is there no mention about the baby? Because I should have been given the option as to why it cannot be taken for granted. It cannot be taken for granted that if a pregnant woman dies, invariably the child will die. That cannot be the presumption. So why there is no discussion even in the medical boards which were constituted, in their opinion, which were submitted in the GR case. In the GR case, they had submitted a opinion. The IO has submitted the medical board's opinion among the papers. In that particular opinion, also there is no mention about the baby. Only then it struck me, because at the time of filing the FIR just after my wife's death, I cannot be expected to go into the nitty-gritties of the entire factual circumstances of my case. So that is the reason why the FIR lodged by me on 15th of July. On 15th of July, my wife had passed away. On that day, I could not have been expected. Regarding the other assertion with respect to cardiac arrest, the statement given by Dr. Nirupa Jodhani was that spontaneous circulation of the cardiac rhythm was achieved. So we do not know at which point of time the cardiac arrest had reached such a situation that the baby could not have been saved. This is a very specific point for determination, which can only be determined by an expert body. Regarding the repeated emphasis on Jacob Matthews case, I've already submitted Martin F. D'Souza's case because this has been considered in this subsequent judgment of Martin F. D'Souza. The duty is primarily cast upon the court to constitute. Regarding the cognizance order, they have stated that 2022 was not complied. These are irregularities with respect to the cognizance order, which I've already submitted, that it is not sustainable in law, even in view of Jacob Matthews' case or Martin F. D'Souza's case. Lastly, 316, only I will briefly sweep through the recital. Section 316 basically creates a legal fiction. It creates a legal fiction. It does not contemplate a situation where the unborn child itself is killed by a direct action. 316 says, whoever does any act under such circumstances, that if he thereby caused death, he would be guilty of culpable homicide. If in the mother's case, if this particular absence, this complete absence of an attempt to save the life, if this had taken place in respect of the mother, then it would have come under culpable homicides definition under section 299, because 299 is not only intention, it also covers within its ambit knowledge. If no attempt is made to save the life of a particular patient in the ICU with the specific knowledge that if I do not take these steps, that is going to cause the death of the person, so that would come under the definition of a culpable homicide. And the illustration which has been given under 316, it is not exhaustive, because the illustration given in the penal code, they cannot be expected to be exhaustive and take within its ambit all sorts of factual situations which might come for an interpretation of the section for which the illustration is given. And does by such act cause the death of a quick unborn child. The act here is negligence. Probably it completely spilled over their head. It might have been so that they did not consider that this particular possibility, that yes, the possibility was there that the life of the child could have been saved. So that is my interpretation with respect to section 316. Even if 316 doesn't come, 304A will specifically come, because the ruling word is negligence. Negligence and manslaughter, they stand on completely different.
Martin D'Souza reply করছেন। The judgment in Martin D'Souza, my lord, with utmost respect, has been held to be bad law. I'm just trying to find out the judgment. There are 2-3 judgments, my lord, where it has been said that it does not hold a good law. It is not a good law, because it is in contradiction with the judgment of Jacob Matthew, my lord. Citation to case in Martin D'Souza. SCC judgment person. I'm just trying to find out, my lord, the judgment. I'll give the judgment. Twice it has been said it is not good law. Yeah. It's a judgment of Honorable Justice Kajju, my lord. Martin D'Souza is Honorable Justice Kajju. It held to be bad law, my lord.
I'll have to check on which point it has been. If I can quickly go through the judgment which says that it is bad law.
Inside the courtroom, my lord, the internet doesn't want to work properly. Where is it? The judgment in SCC, I think it is not showing. No, to pull is page number 249. No, whom to demanding citation to? Yeah, Martin D'Souza citation to.
Governor AIR 2009 Supreme Court.
2009 should be page number 2.
2049.
2049 to लिखा है. I'll not detain your lordship, and I'll give the citation, my lord. If your lordship has some other matters,
They talk about this,
my lord. Yes,
this
yes,
it's not a
yes.
that
That is I'm trying to find out, my lord.
I'll also try to find out that particular judgment. Anyways, I'll be filing a written submission by tomorrow, and I'll be handing it over to the bench.
Yes, yes, we'll file it.
It may not be tomorrow. We'll take 2-3 days. Maybe on Friday.
Friday tomorrow. Not obvious.
From Monday.
On Friday we will file it. Today's
Thursday.
Today's Thursday. Tomorrow we have to file it.
I'll be filing it by tomorrow. In any which case, the ratio which has been laid down in Jacob Matthews' case, it says it may not be entertained. It does not say it shall be dismissed at the threshold, because the direction is also given to the investigating officers, because it is not within my powers to get access to the treatment papers with respect to my wife in the Apollo hospital. And even if I get a copy, I cannot constitute the board, because that is the specific reason why the Maharashtra High Court's judgment, the Bombay High Court judgment says that even the opinion obtained from Maulana Azad Medical College, that was rejected. It was only the opinion which was sought by the criminal court from the Delhi Medical Court. Only that was relied upon. It is not within my powers to constitute a board. How will I, and even if I come with a complaint, will it be independent?
My lord, let us read Martin D'Souza once again. Does it speak of board, my lord? Para 52, my lord. With all due respect.
Committee.
Does not say.
Committee.
Jacob Matthew.
No, Jacob Matthews, Martin F. D'Souza.
Martin F. D'Souza is not the good law, my lord. Correct law. This is a 3-judge bench decision, my lord. That is a 2-judge bench decision. It does not say medical board. It says preferably from a doctor in government service. Para 52, and I have shown, my lord, how Para 52 has been interpreted by our High Court, my lord. In the 2013 Hansaria judgment, my lord.
Now, if an absolute complete blanket is given to the doctors that the victim of a particular case of medical negligence is in such a situation that he cannot obtain a report from a person of, because I do not have the papers with me. How will I be able to?
Saying that, my lord. That is Supreme Court is saying.
Because it may not be entertained.
My lord, the protection has to be given to the doctors.
Definitely.
No doctor will deliberately kill a patient, my lord.
Definitely.
Where is the mens rea? What will I gain, my lord? Where is the meeting of minds that no, let us kill the baby? When a patient comes to Apollo hospital at 12 o'clock at night, will the doctors conspire and think, no, let us kill the baby and the mother both? Will derive some fun. That cannot be, my lord. We try to save the child, mother and child. Unfortunate things happen, and that is what, if your lordship reads the judgment, I have not troubled your lordship, reads the judgment of Jacob Matthew, my lord. Everything has been dealt with. How we tried to take out our anger upon the doctors when something happens. We have got full sympathies, my lord, but cannot be proceeded criminally, my lord.
Doctors
Civil case, definitely.
Doctors definitely need the protection. That is why I am re-emphasizing upon the medical board's opinion. That is the safest course of action for the doctors. Because if the board opines and board says that there is no prima facie case of negligence, they are completely out of it.
That is the question of board.
That is,
my learned friend is relying on board, my lord. Where does it say board? It says a government doctor. Take the paper, send it to the doctor, obtain an opinion. It's a 3-judge bench, my lord. It's binding on everyone. Martin D'Souza goes on to say something else, my lord. Martin D'Souza says that even in case of civil negligence, my lord, a report has to be taken. Supreme Court in subsequent judgment says that no, Jacob Matthew has not said that. So that is not good law. We will not rely on a 2-judge bench decision when there is a 3-judge bench decision holding the field. We will rely on Para 52, my lord, not on that judgment.
Jacob Matthews' case says that the private complaint, if it is not accompanied by an opinion of a competent medical doctor, it may not be entertained. It does not say it has to be dismissed, and it has to be thrown at the very threshold. That is why the direction has been given to the investigating agencies or the
My lord,
investigating
here,
officers.
here, my lord, that
to the
stage is
investigating
over.
officers, so that the investigating officers can take the opinion from a from a government doctor. This is not within my powers. I do not have the papers, first of all. I do not have a single paper relating to my wife's treatment. How will I constitute a board, or how will I get the opinion? The doctor, the government doctor will opine on what? Based on what? The victims of medical negligence, they cannot be thrown into an absolute sea, into a helpless situation.
Now,
This would be
2010, 5 SCC, page 513.
Okay.
513. 2010, 5 SCC 513. V. Kishan Rao. What my learned friend is submitting, that the court, that stage is over, my lord. The court has taken cognizance. Now the matter cannot go back, my lord.
Okay. Something that can it be remanded back?
How? Where is the question of remand, my lord? Where is the question of remand?
On that,
In 482, my lord, where is the question of remand? That stage is over. It's not a civil proceeding that lordship will remand it back in appeal or revision.
No.
Where is the question of remand?
460 and 461 is absolutely clear on this. The kind of irregularities in a cognizance order which will vitiate a proceeding, and the kind of irregularities in a cognizance order which will not vitiate a proceeding, those have been laid down. 460 and 461, these are part of my argument.
Exactly, my lord. What are
Because the
materials on which
cognizance
it has
order
taken
cannot be
cognizance?
taken as an annexure to the complaint. As if the cognizance order goes, the complaint case also goes along with the cognizance order.
Has to be, my lord. If the cognizance order goes, what remains in the complaint? my lord?
No. Read 460, 461.
I think my learned friend should be more careful in saying how to address his colleague.
No, please kindly see. This is part of my submissions. You have not responded to it. That is why I'm saying.
What exactly is your submission? That there is a technical irregularity? No. Let us read the cognizance order.
There is any
Where is the irregularity, my lord?
that was his submission.
Where is the
Yes.
irregularity?
Irregularity is that of taking cognizance without taking the opinion of a medical board.
That is an illegality, my lord. That is a bar created by the law, by the Supreme Court, that you could not have taken cognizance. Irregularity is something that without taking evidence, you have taken cognizance. Here, after taking everything, there is no material in the complaint. In spite of that, with mechanically you say, no, 192, 3048, everything I take cognizance. That is not a material irregularity, my lord. That order has to go. It cannot be said. Then it's no question of remand, my lord.
The principle of actus curia neminem gravabit, that would hold the law, hold the field in this case.
We will respond, my lord. I'll file a written submission. A definition of person, 304 will not come, my lord. 316 is clear. 316, not only 316, but in the previous sections also has to be read, my lord. What is a quick unborn child? That will not come within the meaning of person, my lord. Then it will be a whole different meaning, my lord. I again refer to that judgment of the Allahabad High Court. There has to be something done to the mother, my lord, which amounts to culpable homicide. While giving treatment, if the child dies, 316 cannot come there. In a given case, 304A might come, but 316 will not come. That is my respectful submission.
We'll file a written submissions by tomorrow.
In the written submissions, we will not annex the judgments. Judgments are there. We'll only refer to the judgments. Or should I annex the judgments again?
No.
Only will refer to the judgment. Yes. Obliged.
if I get that tomorrow, it's okay. Otherwise,
We'll try, my lord. We'll try our best.
at that time.
If not, my lord, if not, we'll hand it over to madam by Monday.
Like that. If it gets more, then fine.
Document
Okay,
only,
ma'am. So you are also saying something on what? So you are representing Dr.
Himlina.
Gautam. Yes, sir. Okay. Okay.
Your Lordship, I just reflect that we would be submitting the written submissions later on, later by tomorrow or in the.
You can.
Okay. Obliged.
But
May please, your Lordship. Lordship, my senior Miss R.D. Majumdar, who is the amicus curiae in this case, is in court number 24, Lordship. And a matter will pass over for the time being.
time being, or in fact, how may it from the prepare from your side, it will take half an hour, 1 hour. What will be the time taken by you?
If
For the
my Lord she submits, my Lord, I will not take much time. Because she is ready with the matter. Just it has clashed with court number 24. That is why. Tuesday के बाद नहीं Tuesday 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 कोई बात
It's obvious it's the case of 2010.
Yes, my Lord,
That
all
is
matter. Well, Lordship, may wait for some time, at least 10 minutes, Lordship.
Other method done.
On Tuesday next then, my Lord. Coming Tuesday.
On Thursday. In Tuesday we have some method.
My Lord.
So don't take
Thursday. Thursday.
on 8. It will be
Yeah.
written as proper.
Obliged, Lordship.
Yes, 29. What kind of method? Appeal against conviction under which section? Appeal under conviction under which section? Appeal against conviction.
Appeal under conviction is which section?
Key question?
Section 2.
My pleasure, Lordship.
376.
366 and 376.
Yes. You can start.
May I start, my Lord?
Yes.
My Lord, this is an appeal, my Lord, under 374 CRPC against the judgment and order of the learned session judge of Mangalore, passed in session case number 200 GM of 209, my Lord. In this case,
the appellant Rustam Ali has been convicted under section 366 and 376 IPC. Under section 366, the appellant has been sentenced to RI for 5 years and 1,000 fine, and under section 376, RI for 7 years and 1,000 fine. In this case, the case is that the appellant Rustam Ali had kidnapped one 14-year-old girl, Jasminara Begum, while she was returning home from her workplace. And she was taken to a jungle. There she was raped. Then she was